An hour and 90 minutes in traffic, that'd be an hour and a half, 90 minutes, yeah. So thank you for getting me here on time, and let's get us all home safely. Your name? Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. We'll pause briefly while Mr. Boatwright assumes his lawful position and lofty position. There you go. Okay, so do we have any citizen input on non-agenda items, Pat? No. Okay, just checking. Then I will entertain a motion to approve the minutes of the August 28th minutes for the Planning Commission.
I make a motion to approve the August 28th.
All in favor say aye.
Aye.
Aye. Opposed? Any new business? Okay. We will now consider a request for a minor land partition to partition two lots located at 2570 and 2590 North Maple Courts into three parcels to create a flag lot between two single-family dwellings. The matter presently before the hearing body requires a public hearing. All interested persons in attendance shall be heard on the matter. If you wish to testify on this matter, please be prepared to step forward to the microphone at the appropriate time. State your name, mailing address, and interest in the matter. For those people other than the applicants that are interested in testifying as either proponents or opponents, please sign in on the sheet or speak up when we call for testimony. For longer presentations, proponents and opponents may buy time from one another. In so doing, those either in favor or opposed may allocate their time to a spokesperson who will represent the entire group. You may be limited by time for your presentation. Generally, the applicant will have a total of 15 minutes to speak. The proponents will be given 5 minutes each, the opponents will be given 5 minutes each, and those thought to be neutral on the matter will be given 5 minutes each. The applicant will then have 10 minutes for a rebuttal. All questions must be directed through the chair. Any evidence to be considered must be submitted to the hearing body for public access and to become a part of the record. All written testimony received both for and against prior to the hearing shall be summarized by staff and presented briefly to the hearing body during the staff report. Testimony and evidence must be directed toward the applicable review criteria contained as indicated in the staff report, the comprehensive plan, or the applicable land use regulations which the person believes to apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Land Use Board of Appeals based on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government to respond to the issue may preclude an action for damages in circuit court. Everyone present is encouraged to testify, even if it is only to concur with previous testimony. At this time, I would ask that any member of the hearing body who has a conflict of interest to please indicate the nature and extent of the conflict and whether you intend to participate in or abstain from hearing the present matter.
Nope.
Also, if any member of the hearing body has had any ex parte contact with anyone prior to this hearing, including a visit to the site, please declare the nature and extent of such contact at this time. Okay. Does any member of the audience have any questions for any commissioner regarding conflict of interest or ex parte contact?
I do not.
You do not. The public hearing will be conducted as follows. First, we'll have the staff report, and then questions, if any. Then the applicant, not more than 15 minutes. The proponents, not more than 5 minutes each. The opponents, not more than 5 minutes each. Those being neutral, not more than 5 minutes each, and then 10 minutes for rebuttal if necessary. At that time, we will close the public testimony, and then more questions, and then there will be deliberation by this body, and there will be no additional testimony unless specifically allowed by the chair. A decision shall be made by the hearing body at the close of the hearing, or the matter will be continued to a date certain in the future. This will be the only notice of that date you will receive. Does anyone have any questions about the procedure outlined for this hearing? Okay. Brian, it's all yours.
Great, appreciate you getting us started. This request is called a minor partition. Minor means there is no public street, new or any kind of street that is proposed with the partitioning. And you see up here on the map, we have the area that's involved, and it includes 2 different existing tax lots. Each one has a home on it, and you can probably see with the existing property line here that these 2 existing lots are much larger than the remainder of the lots that were platted in this subdivision, these corner lots. And so that enables them to consider creating another lot, as indicated in this proposed layout, where you have a flag lot with an arm that comes down and a reorientation of the property boundary so that we can put another lot in here somewhat to the side and behind the other existing houses. We're getting more and more of these, and they generally do not cause a problem, but we are finding that it's becoming a little bit more difficult to meet all of our ordinance and public works design standards. That public works design standards were adopted in 2012. And so I'll give you an example on this one, is that we have to make sure that the setbacks of the property lines on the new lot are adequate distances from the existing homes, and those are met with a side yard boundary here from the existing house, so there's a minimum 7-foot separation here. And then you have the same thing over here to this particular lot. And so they have plenty of room to propose these new boundaries. But as you come out on the arm, when you have an arm that's less than 100 feet in length before you get back to the body of the lot, the ordinance allows the driveway width to be as low as 12 feet wide. The ordinance asks that that 12-foot arm be paved its full width out to the street. We also have a requirement in the ordinance that the driveway, paved driveway, as you come down towards the right-of-way line, which is the property line along the street, that at that point you're 5 feet from the property boundary. As you come back up in the lot, you can be as close to the property line as you want to with your pavement, but right at the property line at the street, we want a 5-foot separation. And the idea is that if you've seen how driveways are installed as they connect to the public street, they put wings on them. If you've ever walked on a sidewalk, you see that the driveways kind of wing out. Well, we try to keep those wings from being in front of the neighboring property. And the only way to do that is to separate it at that right-of-way line so that you'll be able to get those wings in without crossing over in front of a neighboring property. It's not a horrible thing if it should happen, but it's kind of an impact that we're trying to avoid on your neighboring property because of some action that you're taking. So we believe that this request will meet the paved driveway and the 5-foot separation from this proposed new boundary, because as you can see, there's another driveway existing right across that property boundary. And what we found is that that driveway is a fairly new one, but it was after our 2012 Public Works adoption that asks for a 10-foot separation between driveways on a local street. So what we're going to have here is we'll have 5-foot separation from this property boundary and approximately 3 foot on the adjacent existing drive. And so between the three standards we have, it's that 10-foot separation between driveways, which used to be 0 before 2012. And so you'll see most driveways are not meeting that across town. But now we're trying to make that separation to keep that impact from your adjacent property. These two properties are owned by the same person, so he's impacting himself. And it's like 7 to 8 foot separation rather than the 10-foot separation from edge of driveway to edge of driveway at the property line. So I wanted to point that out, and of the three standards, the Public Works Design Standard is one that we're most easily could look at an understanding of waiving, providing an exception, because it's not an actual ordinance standard, it's a design standard. And they're meant to be more easily changed as things come along so that they can make adjustments and such. Not that we're recommending that we change this 10-foot separation, but we've done everything we can in order to make this driveway in the best position it could be in, still meet all the setback requirements and the other separation requirements. So the couple of the conditions, other conditions that are indicated with this is that this new lot that's being created will be subject to the residential infill standards. And so we've just cited that section of the ordinance here, and as a building permit comes in, we'll make sure that they're meeting the various standards that are subject to our definition of an infill lot. And that happens when you have two adjacent lots that already have an existing home there for more than 5 years, in order to help make it a bit more compatible. So it's highly unlikely because no one requested one, but condition 2 says if a utility service agency does request a utility easement along the front edge of the property across the arm basically that goes out there and the two adjacent lots, they will dedicate that necessary utility easement. What we found out at our pre-application meeting is all the utilities are in the street, and so there shouldn't be any need for a utility easement. It's a standard requirement we put on here just in case at the last minute one of them needs an easement, because on all new subdivisions we have adjacent utility easements on the private property. We don't have one here, but it's not likely that we'll need one. So we talked about the two driveways conditions here, 3 and 4, and the 5th condition here is that I'll go back to the drawing, it's easiest to see it there. See it from that one. So where the existing property line is, there is a utility easement going down that property line right now. And so that is going to become the new building site of the new lot. So they're going to have to vacate that utility easement. And so that's an action that they need to work on before they can file the plat of record here, so they can delete it basically from being on the plat. So far, no one has indicated any utilities in that easement or any concern with vacating it, but there is a process they have to go through and get agreement from all the utility agency providers that could possibly make use of that existing utility easement, put it in writing that they're willing for the plat to exclude that when it gets filed of record. So based upon the application that was submitted and the facts and findings that we've provided in the staff report and the conditions that we've listed, staff recommends approval of this particular land partition. Are there any questions?
Questions? Thank you, Brian. Pat? I'd say proponent, or you're all there is, so, man, you have a monopoly on it.
Good evening, Pat Sissel Engineering, 375 Portland Avenue, Glasgow. Shall I do this again? Pat Sissel Engineering, 375 Portland Avenue, Gladstone. I'm here tonight on behalf of my client, Dave Harris, who has lived at the home at 2570, the more western and southern of the two properties. He had lived there for many years and always looked at that deep corner that sat back in there and envisioned another home. When the opportunity came up to be able to buy the neighboring property, he did. And that has led to me being here before you tonight. So he's owned the neighboring property for a little over a year now. And we've been working toward pursuing this partition and getting just the right distances off the two homes. And we went out and measured and staked and went back and remeasured and staked again, and he's happy with the plan at this point. The two properties combined have nearly 33,000 square feet. The maximum, the R1 zoning and lot size requirements are between 7,000 and 10,000 square feet. So even with a third parcel in here, these properties are going to average more than the maximum permitted in the R1 zone. So there's a lot of land tucked back in that corner. And it's not unusual to see property lines go to a corner like that, but we usually don't try. We try to square those off most of the time because you're left with kind of an area that's difficult to do anything with. So basically we're trying to take this corner and make it a little more standard, and it's a good spot to fit one new home in with little impact to anybody, because this particular home is going to be bounded by two homes that the applicant owns, and then on the back side is Willamette Valley Country Club's pro shop and parking lot. Brian brought up that issue of the utility easement that runs through the center of the property. The applicant has been there for years, and he has assured me that there are no utilities in that particular easement. It was very common about 12 years ago. In fact, it was a requirement in Canby and other jurisdictions that you had to put a utility easement along all lot lines until the state made that no longer the case. So those were common. They're difficult. They're somewhat difficult to get rid of, and to go through the work to get rid of them when there's no utilities in them, I think is the reason why the state said that basically utility companies can't require these easements unless they have a need for them. So shouldn't be a problem to vacate that easement. And then just wanted to touch on that issue between the two driveways. I think one of the reasons why the design standards want the 5 feet between driveway approaches is typically sidewalks are curb tight. And when you have a curb tight sidewalk, ADA is a concern. And so you need room to transition from a flat driveway approach up to a full height curb and then back down. That takes 5 feet to do that. In this situation, there is no sidewalk really in the neighborhood. So it kind of alleviates that concern for the ADA issue. The applicant would really like to maintain a parking space between the one driveway and the approach, and fully meeting the design standard eliminates a parking space by a couple of feet. So that's kind of the intent behind squeezing the existing driveway on the more northern of the two parcels. So I don't have any other, anything to bring up. I'm happy to answer any questions that you have.
Any questions? So you guys are happy with the conditions that are in here?
Yes.
Okay. All righty. Thank you.
Thank you.
Now we will hear from any proponents. Seeing none, there will be none. Any opponents? Also seeing none, there will be none. So let's quickly scamper along and close the public testimony. Questions for staff? Okay. More discussion. So I will entertain a motion to approve a minor land partition to partition 2 lots located at 2570 and 2590 North Maple Court into 3 parcels to create a flag lot between 2 single-family dwellings.
Mr. Chair, I will make a movement to approve minor land partition to partition 2 lots located at 2570 and 2590 Maple Court into 3 parcels to create a flag lot between 2 single-family dwellings as per the conditions of approval from staff.
Any second?
Second.
All in favor say aye. Aye. Opposed? Okay. Now we will have a final decision, so no public testimony. So can I have a motion to approve MLP 17-04 David Harris?
Mr. Chair, I move that we approve MLP 17-04 David Harris.
Second.
All in favor say aye. Aye. Opposed? Thank you very much, Matt. Good to see you again. Any items of interest from the staff?
The first item would simply be what's not on the agenda for discussion is about the parking issue that came up at our last meeting. We had talked about delay of required parking spaces, and you actually did not approve their request for a delay, but you thought maybe we should look into that a little bit more. We have not had time to do that. I'll explain that next. But you might want to continue thinking about that a little bit. The idea of trying to figure out when it's appropriate to delay and when not seems a bit difficult, but we can continue to think about that some more. And another approach we might want to take is figure out certain circumstances, such as when we have warehouse uses, possibly making the standard itself different than it is for manufacturing uses. Right now, they're the same thing. And so that might be another way we might address it, so that, because it's going to be difficult for us to come up, when do we agree to delay parking and when do we not? So that was our thought about it so far, is to think of a different approach, maybe change the parking standard.
And how do we go about doing that? Because that makes an eminent amount of sense.
And that'd be a typical text amendment. We'd bring forward either a proposed wording, or we'd bring forward for a discussion first, so that we would know, what direction marching orders we have in order to prepare an actual text amendment. And we might throw it in with some other things we're working on as well.
When do you think that you could?
At this point, all bets are off. I mean, we've been working for 2 years on, we're sinking right now, and without any additional work on text amendments. And so we'll try to get to it. And so I wanted you to know I was aware of that request, but we're having trouble getting to those.
Think of it as a full employment opportunity.
Exactly. So the other thing, I don't want to get into discussing it now, but wanted to forewarn you, so to speak, of the next meeting that we're having. We do have 3 items. 2 you're pretty familiar with. I guess they're minor. Both of them are minor land partitions, and so you've been doing quite a few of those. The third item is the proposed subdivision on North Maple Street, which has been contemplated since 2015. And if you take the previous two applications that came in the past 30 years on the same property, it's been contemplated for quite some time, and it's been thwarted twice before. And it's probably even more controversial today than it was the previous two times that it came before us. And there's seems to be some of the difficulty seems to have to do with the proposed improvement to North Maple Street to the subdivision, which is completely off-site from the subdivision itself. And the proposals right now are appear to be fairly clear, but yet they're not, because they haven't secured the ability yet to make what they're proposing to do, because it involves private property. And so they're negotiating with the private property owners in order to do what they're proposing to do and hoping that they'll be successful. So that's really making it quite confusing at this point. We're hoping it will be resolved by the public hearing, because it's been advertised, it's on the agenda. But right now, it's still uncertain as to exactly what they'll be able to do. We know what they're proposing to do, and when you read about it, I wanted you to be aware to try to make the distinction of what's in their narrative and what they're proposing and saying they can do, and the fact that they haven't actually secured or bought the property to be able to do that yet. Just wanted you to be aware of that as you're trying to read through that complicated
How
case.
soon will we get our packet on
We're
that?
hoping this Friday.
Okay.
That's all I have.
Is, you will not be here for that?
I will not be here. I'll be here.
I'll be here.
Because for something like this, we have to make sure, I'd like to be assured that we're going to have
Yeah.
a quorum.
Yeah, and then the other thing is you'll have a complete packed room full of people, and I want you to be prepared for that. And if for any reason, whatever the circumstances, you feel like you might need more time, or one of the parties requests an extension, that's certainly within your purview to allow that. Usually when you do that, if some new information is submitted, then there's the potential that the other party might ask for another extension so they can respond to the new information that was presented at the first extension.
Okay.
So we do it before you tell.
Sounds like the Fred Meyer gas station to me, so, all over again. Okay, then it sounds to me like we'll have a quorum, so we'll be prepared for that. Everybody wear their packed room, will be on TV, so we'll all want to look our best. So any items of interest from us for staff? Okay, and I will entertain a motion to adjourn.
Mr. Chair, I move that we adjourn this meeting.
Second.
All in favor, say aye.
Aye.
Opposed? Thank you very much.
Sarah, I got a question for you.